I am Ryan McKnight.
I'm Cara Santamaria.
I am Christopher Smith.
Hi, I'm Andrew Torrez.
This is Naked Mormonism,
the serial Mormon history podcast. Joseph Smith has been on the run from the law since 1839. But more recently, he'd been hiding out since he was fingered as a primary suspect in the Lilburn Boggs assassination attempt. Now he had been to court and was granted his writ of habeas corpus, but his legal troubles were far from over. I wanted to get a bit of a more objective take on Joseph Smith's legal sphere in 1843 here, so I've invited illustrious host of the Opening Arguments podcast, as well as proprietor of the law offices of P. Andrew Torrez. Andrew Torrez, thank you so much for joining us and welcome.
Hey, Bryce, thanks for having me on. This was super fascinating because, as you know, I practice law in the 21st century and not the 19th. So this is a super interesting question to try and tackle.
More than anything, I wanted you to come on here to fact check me and hopefully give us a little bit of a forecast of what Joseph Smith's legal troubles look like moving forward. Because 2 episodes ago, we covered the 1843 January trial wherein he was being tried on whether or not he would be granted a writ of habeas corpus. But obviously that was, we came down to the ruling on that case that the court did have jurisdiction and that they would indeed grant his writ of habeas corpus. But I kind of want to go through the legal procedures of why they were making the arguments the way that they were and what the Attorney General of Illinois was trying to do in order to get Joseph Smith extradited. So I'm hoping you can shed a little bit of light on this situation. After reading the court document itself, what kind of struck you from it?
Sure. Okay. So let's set the stage here. What you have is a warrant for extradition. In fact, 2 of them, right? One signed by the governor of Missouri and one signed by the governor of Illinois. And so that is particularly the one signed by the governor of Illinois is going to have the force of law within the state of Illinois unless Joseph Smith can appeal to a higher standard. And here I don't mean I do not mean God. Right. The laws of the United States, right? Trump even
federal instead of at the state level.
Right, even what governors want to do. So Smith has to win on 2 consecutive arguments. If either one of these fail, then the warrant of extradition is presumptively valid, and state marshals would escort Joseph Smith in custody to the state of Missouri, where he presumably would have stood trial and most likely had been executed. Right. So,
well, and when we just look at the facts. Before he attained the newest writ of habeas corpus from the Springfield court, as it stood before that point, it was within the constitutions of both Missouri and Illinois that when one governor of one state sends out an extradition warrant to another governor, that the governor of that state that receives that extradition warrant is to honor that without asking questions, essentially. That's the kind of long and short of it. So it seems like at that point, at that level, it's valid for Governor Carlin to grant Governor Reynolds' extradition warrant that he sent to the governor of Illinois.
Yeah. And let me add, on top of that, there is a constitutional requirement, in fact, that states do that. It is called the full faith and credit clause. And it says that courts in one state must give full faith and credit to the decisions of a court in another state. Right. So even if it were not specifically within the state constitutions, that's absolutely how the law is meant to work. So The question is, how does Joseph Smith kind of navigate around this? And the answer is, this is really, really clever. What he's managed to do, it's really good lawyering, right? Like he's got the better of the argument here, even though he but the preponderance of the historical record seems to indicate that he ordered an assassination of a former governor and former senator, right?
Yeah.
So here's what Joseph Smith did. He went to a federal court. In this case, the U.S. District Court for the District of Illinois, which tells you something about the size of the state of Illinois in 1843. In Springfield, which in addition to being the town of my birth, is literally at the far south of the state of Illinois, right? And so it is as far away from Chicago as you can get, right? So Joseph Smith goes into federal court and says, I want this court to recognize the federal grant of a writ of habeas corpus as trumping these two state warrants, right? So here are the two arguments that Joseph Smith has to win. He's got to win, number one, that the federal court can do something, right? That they have jurisdiction over this case. And then number two, he still has to win on the merits of the argument for habeas corpus. If all the state of Illinois had to do was knock out either one of those arguments, right? So in other words, if the court lacks jurisdiction, then it doesn't matter what the facts are. Then there is no body that can grant Joseph Smith any kind of relief that would supersede the extradition warrant, right?
Okay.
And so that's why that's the first argument that the Illinois Attorney General is making. But then, even if the court has jurisdiction, there is still the argument on the merits. So, you might be thinking, okay, well, if I today were to order out a hit on Bryce Blankenagel living in Washington,
it's a very odd,
just totally
example.
Hypothetical, right?
Okay, all right.
And I were to be tried for this crime, I could not go to a court in Maryland and petition for a writ of habeas corpus, right? Even if I could go to a federal court in Maryland and it had jurisdiction, right, which likely would for reasons that are not important to get into, I could petition for a writ of habeas corpus, but the federal court would go, well, you know what? Like ordering a contract killing on somebody in another state is valid grounds for you to be detained by the state. And habeas corpus is the writ that you petition for when there are not valid grounds for the state to be holding you, right?
Right.
So in other words, right, you have to win at both stages. So how does Smith, through his lawyers, how does he do this? First, the jurisdictional question. Joseph Smith is 100% correct here in this argument. I know that seems kind of crazy, but here's the way it works, right? In your state right now, in every state of every person listening to this podcast, there are two parallel courts that exist. Oftentimes, these are in the same building complex, sometimes even in the same building, right? And there will be...
Right, it's state versus federal, right?
There will be a state court sitting next to a federal court. And here's what you need to know. State courts are courts of general jurisdiction. So anything that you want to take to court, you can take to a state court. They can hear literally anything that you bring before them. Now, again, that doesn't mean, right, if you sue somebody and I say, I'm going to sue Bryce because he frowned at me, the court has jurisdiction to adjudicate that claim, right? They would then...
Right, and then I'm going to countersue for defamation, claiming falsely that I frowned at you.
Yeah, well, I doubt you would prevail on damages on that. But no, look, what you would do is you would move to dismiss, right? You would say... Right. Even if I frowned at Andrew, there's no law that says I can't frown at Andrew, and there's I have no civil duty not to frown at Andrew. And even if I did, he couldn't possibly have suffered any damages as a result of my frowning at him, no matter how sad that made Andrew.
Right, of course. But I mean, the facts of this trial are a little bit different, right? Because Boggs was still recovering from 3 bullet holes in his head. Yes,
a little bit different, right? So, but that's jurisdiction, right? So the point is that even if it's a frivolous argument, state courts are courts of general jurisdiction. They have the power to decide and answer those questions.
Okay.
Federal courts are courts of limited jurisdiction. They only have the authority to decide the kinds of cases that have been delegated to them by the Constitution or the Judiciary Act of 1789 to decide. Let me, and I know that this is sort of a difficult concept, but so let me give you the easiest way that I can think of to explain this.
Yes. Explain like I'm five. Thank you very much.
You and I sign a contract. I allege that you've breached that contract. Okay. And then I go to sue you. I can sue you in state court, right? I cannot sue you in the Supreme Court, right? Even if it's true, right? The Supreme Court does not have jurisdiction over contract disputes, right? The Supreme Court only has jurisdiction over cases where they issue a writ of certiorari or a couple other tiny exceptions it's not worth going through right now.
Right. And that only happens after state courts have heard a case, and then it is appealed repeatedly through the various district courts and then up to the Supreme Court level.
And beyond that, it must, for the Supreme Court to even touch something, like the Supreme Court cannot issue a writ of certiorari to a state Supreme Court in a case that does not involve an issue of federal law or the U.S. Constitution, right? So, in other words, if it is literally like you and I sign a contract, and suppose we sign it in the same state, right? Let's say there's no interstate commerce, there's no question of anything, right? Like I'm out there visiting Washington, we sign a contract, I allege you breached the contract. That case is never getting into federal court, and it can never go to the Supreme Court. So it seems kind of weird, but in many ways, right? Like the Supreme Court has less power than state courts because state courts are courts of general jurisdiction. Federal courts only can hear the cases that they are empowered to hear. Okay.
Okay.
So
that kind of sets the foundation for why Joseph's counsel was trying to argue that this court did indeed have jurisdiction, that the federal court had jurisdiction to hear whether or not they would grant the writ of habeas corpus.
That's right. And so
interesting.
And so here, Joseph Smith has the much better argument, right? Because the Illinois Attorney General has to come in and say, oh no, we're only here to adjudicate two collective writs that have been issued, right? Extradition warrants, one by the governor of the state of Illinois and one by the governor of the state of Missouri. There's no federal law here. It's just two separate state warrants. And Joseph Smith's counsel basically, kind of reading between the lines here. We don't have the transcript, but did the 1843 version of, come on, right? Like we know that what you have here is the effort to transport somebody across state lines. And in fact, the reason, if you read these warrants, and we can talk about the text of some of the extradition warrants, they are implementing a specific provision of the U.S. Constitution. And in particular, that is Article 4, Section 2. And here's what Article 4, Section 2 of the Constitution says. A person charged in any state with treason, felony, or other crime who shall flee from justice and be found in another state shall, on demand of the executive authority of the state from which he fled, be delivered up to be removed to the state having jurisdiction of the crime, right? And in fact, that is what the Missouri affidavit supporting the extradition warrant says, right?
But then Joe's counsel makes the argument that he never stepped foot in the state of Missouri since the assassination attempt, because I was hanging out with 3,000 of my bros, and we were playing in military garb, and I have all of these alibis of where I was at the time, so he wasn't actually a fugitive, technically speaking, since the assassination attempt.
So we're going to get to that because that is the argument on the merits. But right now you're sort of seeing the trap that Joseph Smith's lawyer has laid for the Attorney General of the state of Illinois here, right? Because if you're Smith's lawyer, right, you can go into court and you can go, Your Honor, however you feel about the determination of whether Joseph Smith is a fugitive from the state of Missouri or not, and obviously, again, I'm playing the role of Joseph Smith's lawyer here. We think that he is not a fugitive from the state of Missouri. the fact that that question is before this court is why this court has jurisdiction and shows you the pretense of the argument being made by the state of Illinois, right? We're not here on a state. We're not here on an order of the governor. We're here because two governors believe that Joseph Smith has fled from Missouri to Illinois to escape justice and want him remanded back to the custody of the state of Missouri to stand trial in Missouri. If you think that's the question we're answering, then that question has to come before this court. This court must have jurisdiction. And that is, in fact, how the court addressed that jurisdictional question. They said, yeah, look, like it's clear that despite the fact that the state of Illinois is saying we're only here to resolve a state question, we're here on a question of federal law.
Okay, so then I guess another question, then now that we're getting into the part where they're ruling on whether or not he's actually a fugitive from the state of Missouri, he broke out of state custody in 1839 and fled to the state of Illinois from Missouri. So there are still all of the old charges from the Missouri Mormon War that are still hanging over him, that he knows that the assassination attempt of Lilburn Boggs was directly a result of, but the court didn't even hear whether or not the charges of him being a fugitive from the 1839 was actually, had any standing in this case, because this was strictly on the assassination attempt, right?
And yes, and here's why. Because in order to execute a writ, or in this case, a warrant for extradition, that has to be supported by facts, right? And in this case, the facts under which that warrant is supported is the affidavit of Lilburn Boggs, right? And an affidavit is a document that you sign under penalty of perjury, right? It's the equivalent of testimony in court. And, having that from ex-senator, ex-governor, right? Like that's you shouldn't necessarily place more trust in it. But, if I were having an affidavit filled out, I would like to have a former governor over, just, blank Boxman. So,
yeah, right.
So then what the court has to adjudicate are whether the facts alleged in the affidavit match up with the law in which that affidavit is filed in support of. So you have to look at specifically what does Boggs say, right? And Boggs says, right? So here, we're going to use a little bit of the language, and this language is not super archaic. Like we still use this form in the kinds of affidavits that I have my clients fill out today, right? So
right, this is not Saxony. This is America in the 19th century.
Exactly right. And so it says, under the notary, this day personally appeared before me, Samuel Weston, Justice for the Peace, the subscriber, Lilburn W. Boggs, that's the person making the statement, who, duly being sworn, right? Raise your right hand. Do you swear that the facts that you are about to say are personally known to you under penalty of perjury? Yes. Doth depose and say that on the night of the 6th day of May, 1842, while sitting in his dwelling in the town of Independence, he was shot with intent to kill, and his life despaired of for several days, and that he believes, and has good reason to believe from evidence and information now in his possession, that Joseph Smith was accessory before the fact of the intended murder, okay, and that the said Joseph Smith is a citizen or resident of the state of Illinois, and the said deponent hereby applies to the governor to make a demand on the governor of the state of Illinois to deliver the said Joseph Smith, commonly called the Mormon prophet, to some person authorized to receive and convey him to the state and county aforesaid there to be dealt with according to law. Now, all of that, it should not surprise you, matches up with the facts as we've learned in your timeline. Right. Like,
right.
And it is 100% consistent with, look, I don't know if Joseph Smith pulled the trigger. Maybe he didn't, but he sent his henchmen, right? Pistol packing Porter Rockwell out here, and that dude shot me. And let's bring in Joseph Smith because, this is not the 150 years before the Air Bud defense was created, right? Like it's not like there's no law saying, you can't hire somebody to kill somebody else. Another, like, of course you can't do that.
Right. And that's the accessory before the fact. That's the entire point that this argument hinges on.
Exactly right. But now look at what the warrant of extradition says. It says, whereas it appears by the annexed document, right? And that means the
affidavit.
The affidavit that we just went through, which is hereby certified to be authentic, that one Joseph Smith is a fugitive from justice, charged with being accessory before the fact made by one O.P. Rockwell in this state, and that it is represented to the executive department of this state, has fled to the state of Illinois. There you go. So in other words,
that argument is not based on any information in the affidavit.
Exactly right. And it is a foundational principle of law. And look, it's a principle that we want this to be the case. It is a foundational principle of law.
You charge somebody with crimes based on what the crimes are of the affiant.
That is exactly right. And if something, and this is the key part, if a fact is omitted from the affidavit, it is presumed to be false, right? It is presumed not to be in evidence. So in other words, a court cannot supply on a defective affidavit additional grounds that are not present in the affidavit. And let's go one step further here. I mean, this is why it's important, as you led off in the show, that, Joseph Smith was hanging out with 3,000 of his bros in, fancy costume pretending to be a general, right? Like that. That's really strong evidence that he did not, in fact, flee to the state of Illinois.
Right.
And when you look at, and I mean, it's why I love this case and this part of time, right? Like the larger picture that's unfolding here in the United States is we have a constitution that, is 50 some years old at this point, right? It's half a century into the nation that has these agrarian foundings that, if you look at the provision of the Constitution that I read, that was meant to apply. I mean, like on its face says applies to somebody who commits a crime in one state and then flees to another. And the likelihood that the founding fathers thought you could coordinate a murder in Missouri from Illinois, right? That they would have said, well, how right? There wasn't a telephone. How are you going to do that?
How could you foresee that?
Right. And so, by the technical language of the federal law, implementing this provision of the Constitution, I don't know that Joseph Smith fled from justice in Missouri, right? He committed the crime in Illinois. And one of the things that the opinion was based on that was absolutely true across both political parties as of 1843 was the idea that if you commit a crime in Illinois and you're a citizen of Illinois, you should be tried in the state of Illinois.
Yeah, tried in Illinois.
Yeah.
Absolutely.
Why we're not going to drag you into some other state where you don't get a jury of your peers and you get a jury of those weird Missourians. Like, who knows?
Yeah, I looked at Andrew Torrez wrong. Let's extradite both of us to Texas to hear the court, right? Like that's absurd.
Well, and you're used there, right? Like, so you're a, filthy liberal West Coaster and I'm a filthy liberal East Coaster, right? Like the difference between, right, deep blue Maryland, deep blue Washington, and deep red Texas, right, that intuitively we recognize now is the difference between every state that the founders thought, right? Like the founders literally thought like, oh yeah, gosh, I mean, you bring somebody from Connecticut into Vermont, like, are you kidding me? Like, you might as well try us. And this is great language used in this case. Like,
I love that
you might as well drag somebody from France to Spain, right?
Yeah, right.
But that is in fact, the view of the difference between the states at the times. So so Joseph Smith had to win on both arguments, but to be honest, he had the better of both of these arguments because of how defective the warrant of extradition was, and
wow,
and the underlying law, right? Like I don't know, based on the facts that we've described here, that you should try Joseph Smith. In 1842, that you should try Joseph Smith in Missouri. Obviously, the law's changed quite a bit since then.
Well, and that's one thing that I wanted to discuss a little bit with you, because there was still all of the old charges from 1839 and the November 1838 Court of Inquiry that chose to hold Joseph Smith and 5 of his friends in Liberty Jail while the state compiled its case to charge Joseph Smith on arson, robbery, and treason. So with that in mind, when he fled state custody in 1839, he was a fugitive at that time. But because this hearing wasn't hearing any of the merits of those old charges and the documents that were published in early 1841, they didn't have any grounds to claim that he was a fugitive from justice. But that still didn't ameliorate these charges that were hanging over his head. They were still there. If he ever stepped foot in the state of Missouri from that time forward, he would be tried on all those old charges, right?
Absolutely. And if I can make an analogy to an issue that is presently before us, right? Like, you are 100% correct. If the warrant that had been executed by the governor of Missouri and the affidavit that had been sworn out by Lilburn Boggs had included the prior crimes, it absolutely would have met all of the conditions under the statute, right? He committed crimes in Missouri and packed up and fled to Illinois. And by the way, then he got to Illinois and committed more crimes in Missouri. Would have been a super easy thing to do, but they didn't do it. And now
they didn't do it.
Why didn't they do that? Well, look, like, record keeping was a challenge in 1843. You didn't have any computers of any kind to, go through and cross-reference. But this is, and this was the analogy that I was going to make. This is why, for example, the Mueller probe is taking 2 years, right? Like, because today,
evidence.
Right, one of the things that we've learned is that, you assess in a methodical way all of the facts, all of the details, all of the potential violations of law, because you never know how that's going to get processed by a court. And you do not want to be in court with a single argument. And here, their single argument is Joseph Smith was an accessory before the fact. And I can tell you, I'm sure what happened, right? Like, what happened was, right. Lilburn Boggs went to the governor and was like, that guy shot me, right? and they said, look, like, yeah, we've got, it is indisputable. So, all right, let's you swear at an affidavit. I'll get a warrant for his extradition. We'll get him back here. And they didn't think, well, what if there's a defect? What if there's a problem?
What if he hires really good counsel?
And he did. And
and I thought it was quite glaring that in the affidavit itself, it said that Boggs has information presently in his possession that, leads him to believe that Joseph Smith was an accessory before the fact. And, Josiah Butterfield, Joseph's counsel, made the argument that if he has information, why wasn't that included in the affidavit? Right, because that might have been the extra, the way to plug up this hole in the state of Missouri's argument or state of Illinois' attorney general's argument to get him actually extradited. But they didn't include that extra evidence. It was just this little scrap of paper that Lilburn Boggs was, oh yeah, I think Joseph Smith shot me, and that was it. There wasn't anything extra to tack onto that would ensure he would indeed get extradited.
It is worse than that because this is another example of kind of careless drafting. Let me use an analogy to modern day search warrants, right? Like, this would be a valid search warrant, right? And again, same process, right? The way in which you get a search warrant is the police officer swears out an affidavit, the prosecutor hands that application with the affidavit attached to it to a judge, and the judge issues the warrant, right? And then the warrant could be, right, a search warrant or an arrest warrant or whatever, right? It is literally, the process has not changed in almost 200 years. And so, and again, I'm overgeneralizing here, but I don't think we're not doing a whole, we're not doing a whole opening arguments on this, but it would be invalid if the affidavit from the police officer says, I, upon belief, believe that Bryce Blankenagel has criminal controlled dangerous substances in his possession and therefore want a search warrant to that.
You can't prove it.
Right.
Right.
That affidavit alone, based on belief, would not be sufficient. Right? A judge would not grant it. But if same thing, same officer, I say, Officer Torrez, having personally observed evidence and instrumentalities of crime, therefore, on good cause, in support of that evidence, believe that Bryce Blankenagel has controlled dangerous substances in his possession. Then
right.
I get the warrant, right? So in other words, it is, you don't have to list, right? This opinion and the way you were going into it, you were thinking, well, you should list all the evidence. You don't even have to list all of the evidence. You just have to change belief to observation, right? Okay. Again, listing some of the evidence would have been good, right? And you went through and you listed some of the evidence in favor of Rockwell being there. If the affidavit had said, I have observed the following evidence, and it is known to me and known generally in the state of Missouri that Mr. Rockwell is an associate of Joseph Smith, and therefore on information and belief that Joseph Smith was an accessory before the fact by directing Porter Rockwell to shoot me, that probably would have been sufficient. But wow. The fact that it used the word belief and not the word observation was enough for this aside in the middle of the opinion, right? And again, you'd also have to correct the other defects, right? Like you would have to have included the previous crimes, but put it all together, right? Make it a slightly longer affidavit, include the story, say, Porter Rockwell is a known associate of Joseph Smith. They committed the following crimes in Missouri in 1838 and 1839. They fled the jurisdiction in 1842. Porter Rockwell came back in 1842 and on information and belief at the direction of Joseph Smith, shot at me. Here's the evidence in support of that. And therefore, I want a writ I want a warrant to extradite Joseph Smith, return him to Missouri to stand trial for crimes committed in Missouri. Boy, that'd be a very different alternate history. It
absolutely would be. Well, let's take that as a little bit of a springboard to conclude our conversation here, because a writ of habeas corpus basically says, per my understanding anyway, at that time the court or the government doesn't have the evidence to hold your body in its possession at the time, basically. But it's not necessarily a get out of jail free card, right?
Yeah, no, it and in fact, again, kind of flash forward to the future, to today, writs of habeas corpus are petitioned for all the time in capital cases and virtually never granted. Right, like it is very, very difficult because
they learned from Joseph Smith.
Because by definition, the writ does not apply if there are lawful reasons for you to be detained. Right, like you must show that you are being unlawfully held, and the standard for whether the state can lawfully hold you, that again, it's expanded since the 19th century, but is pretty broad and pretty deferential. So yeah, like a writ of habeas corpus is not a get out of jail free card.
So with that said, then the state of Missouri had enough evidence to convict Joseph Smith on conspiracy, on treason, on arson, on robbery, on larceny, on all of these charges from the 1838 Mormon War in Missouri. So those charges, they were not expunged from Joseph Smith's record by any stretch of imagination. They were still very much attached to him. What would it have required then to get him under arrest and get him extradited to Missouri if he continued to remain in Illinois? Would it require a second affidavit from Boggs? Would it require the governor of Missouri, Governor Reynolds, to swear out another extradition warrant that said based on all of the old charges from 1839? How exactly would that have played out? And, obviously that would have changed history, but how would that have worked if justice were to have been served on Joseph Smith's head?
So, The first part of that is a question I can't answer, and I will tell you why. I tried to answer this. And the question is, what is the statute of limitations on arson and the additional crimes with which Joseph Smith was charged in 1838? I don't know the answer to those questions, but but if they were under 4.5 years, right? And you know, the clock might be ticking. If it were 5 years, it certainly could have been 3 years, right? Like we have moved to an era in which statutes of limitation tend to be longer and longer, and in fact are non-existent, right? For crimes of murder and in most states for certain classes of sexual offenses, right? For aggravated rape and things like that. We talked about that a little bit in the Mormon abuse cases. So assuming that the prior crimes are still within the statutory period, then yes, that's the process would have been go back, get a valid affidavit, and come back here when you've got that with facts that support the return of Joseph Smith to Missouri for crimes committed in Missouri. Now, obviously, Joseph Smith, had that happen, would have tried to rely on the preclusive effect of this judgment. But the way I read this case, a tremendous amount of this case hinges upon the fact that the affidavit is defective. Right.
Yeah, absolutely.
And so that's not, when we talk a little bit about preclusion, the state is, any litigant is precluded, that you are prevented from relitigating a fact that has been decided in a court of competent jurisdiction. This is true criminally and overlaps with, the common conception of double jeopardy. But it's also true civilly, right? Like, so classic example of this, I sue you for trespass onto my property, right? I say, Bryce came onto my property and on October 7th and broke a whole bunch of my stuff, and I want damages. And we go to court.
And then frowned at me as he walked away.
But no, trespass is a valid thing I could sue you for if you did it.
Absolutely.
We go to court. You produce affidavits and witnesses that show that on October 7th, you were in fact in front of 3,000 people in Army uniform playing dress up, right? And the court says...
my weekend LARP. Yeah,
right. And the court says, as a matter of law, we determine that, we find in favor of the defendant, Bryce Blankenagel, and that there was no trespass because he was not on Andrew Torres's property on October 7th. Great. Mm-hmm. Then I say, okay, I also want to sue you for coming onto my property and beating me up on October 7th. Right. Then you can go into court and move to dismiss on preclusion effects, right? And on it's a form of collateral estoppel. And again, I don't want to get too much into law geekery here.
Right, but that is not double jeopardy because it's hearing on different charges.
It's on those are civil, right? There's not even criminal, right? Like it is just I'm suing you civilly for damages, right? But I am collaterally estopped. Right, which is a fancy word for I can't go back to a court and go, I know you already determined that Bryce wasn't on my property on October 7th, but I want another bite at that apple. I want to do it again. I want to prove that he really was. And I've got new evidence this time. I've got better, what the court says, no, get out of here. We determine facts once. That's it. So that's what Joseph Smith's argument would be. In this hypothetical universe, he would say, yeah, look, like we were already here. And the court says that, I didn't commit any crimes in Missouri. But in that case, right, I would say that the roles would switch, right? And the Illinois Attorney General would have a really, really good argument. No. What this court determined was that the last affidavit was facially defective. We agree. We went back. We got a better affidavit.
We got a new and a better one. Yeah, we plugged up all the holes.
And in fact, that frequently happens in both civil and criminal cases all the time, right? Like you don't see this very often. It doesn't make a lot of the TV shows, but if a judge refuses to issue a search warrant to a prosecutor, that judge will tell the prosecutor, like, no, hey, look, like this, you're not getting a warrant here because you don't have any direct evidence of X. Well, can you guess what the prosecutor goes back and tells the detectives working the case?
Hey, find evidence of X real quick.
It'd be real good if you had some evidence that X happened, right? And when you do, you go back and you apply again, and the court says, okay, well, now you do. Right? Now you do.
Let's move forward. Let's proceed.
And we will grant the warrant. So that could have happened here. And the only asterisk, I mean, like I said, as we're sort of playing this out, the only asterisk is if the prior crimes were outside the statute of limitations.
Okay.
And again, and if it were close, right, like that would have been, Joseph Smith would have raised that in his arsenal too. You know, he would have come into court and said, look, like the state of Missouri has had 5 years to try and secure my alleged return for the crimes that have now been trumped up in this affidavit. They're clearly, this is all pretext. They've clearly done this because they got slapped down 6 months ago, and this court should not entertain that sort of nonsense. And and again, right, as putting myself in Butterfield's shoes here, that's the argument that time traveling 19th century Andrew would have made. I like to think I'd have mutton chops in the 19th century.
You would look good with it, absolutely, with the current beard that you got going. Okay, so I'm sorry, you've given us a lot of your time, and just one final question before I let you go. I made the point in the episode when I read through this court document that if there existed at the time an interstate police force and an interstate investigative force like the FBI, then they may have been able to gather the evidence necessary in order to charge Joseph Smith at a federal level, and the proceedings may have been altered. So in your how off base or how accurate was that assessment?
So I think that's pretty good. And I would add to it that what happens is that federal laws also evolve to track federal facts, right? So in other words, at the time, the operative statute was the statute implementing that particular provision in the Constitution regarding fugitives from justice. Well, once you have interstate investigation under the FBI, then you no longer have the strict requirement, the temporal requirement that you commit the crime in Missouri and flee to Illinois and thus be returned to Missouri. You would rather have a locus of the crime requirement, right? You would say where a crime is committed and we have evidence supporting that crime, you have to stand trial for that crime in that state. And, you would then specify, right, that accessory before the fact to commit murder, being, hiring a hired killer, is by law committed in the state in which the murder is committed or the attempted murder is committed. So in addition to gathering the information, the law changed because it reflected the fact that all of a sudden it seems kind of archaic of, okay, where you are governs where you stand trial. If, you send one of your minions to go commit trial in another state, that seems an awful lot like you're intending to subject yourself to the jurisdiction of that state. And let me do another 18 seconds on jurisdiction. The test of jurisdiction has always been what we call purposeful availment, right? And the idea is, in order to be subject to a state's laws, you must have deliberately put yourself in that state. And the question is, what counts as deliberately putting yourself in a state? And certainly, right, like, so for civil purposes, right, like if you are driving, say now, none of the previous cases that we talked about as hypotheticals are true. You are driving cross country to see your good friend Andrew Torrez in Maryland. And you've got to drive across the entire United States. And so you're in Kansas and you run somebody off the road in Kansas. That's enough to sue you. That person that you unfortunately hit in Kansas can sue you in Kansas, and you have to go stand trial in Kansas because you have purposefully availed yourself of the law of Kansas by driving through it, right? And but I can't nobody else could sue you in Kansas, right? Like there must be a close locus between what you did and the state in which we seek to try you. Like the fact that you've once driven through Kansas is not enough for me to sue you for breach of contract in Kansas. Does that make sense?
Oh yeah, absolutely. Yeah. So basically, where the majority of the crime was committed, or whether the crime itself was committed in a specific state, or whether you currently reside in a state and caused a crime to be committed in another state, you could be tried in basically either of those states for that.
Yeah.
Is that a correct assessment?
I think that's right. There are a bunch of factors. It's not really important for us to go into all of them.
Right.
But it isn't binary, right? Like that's the point, is that the 18th century conception of, the crime is committed where you are, got supplanted over time with the idea of, well, there's some things that don't neatly fall into that category. Right.
Right.
I planned something in Illinois.
This is one of them.
Yeah. And my henchman carries it out in Missouri. Maybe we should let you be tried in Missouri. Right. And let's go back to that, separate sovereigns thing. Right. Like on the one hand, you can say, well, I'm sympathetic to the idea of taking a poor Illinois citizen and, hailing him off to a foreign state that's almost entirely a foreign country. By 1843, there was also kind of a sense of, well, wait a second, like, why does Joseph Smith's right to be in front of a jury of people that are his friends and neighbors, why does that trump our right to try somebody who had a crime committed here, right? Like why don't we have the same kinds of interests? And those issues got, worked out in this country, over the next 150 years. But you're seeing this really, really cool time slide. I mean, it's cool for me because I'm a law history geek.
Right. It wasn't cool for the people who suffered at the hands of it. But,
no.
I mean, it is still fascinating to say the least.
Yeah. So I really appreciate you bringing this to my attention. This was a lot of fun digging into these documents, and this was not quite as indecipherable as a lot of 19th century legal cases sometimes are. Right, there was not a writ of assumpsit and an action in assize and the pur and pui and oh my, those are real words, right? Like
wow,
it's nuts.
This was still, it was really fun to, I guess, venture out on a limb myself and try and then have you come back and verify essentially the way that I was able to assess it and add so much more context. That's the important part, is adding much more legal context to this and the way that it was viewed more in the time that it was committed as opposed to the way that we might view something similar, similar situation today. But of course, Andrew, once again, I want to thank you for taking so much time with us. Listeners, if you don't know Opening Arguments, you need to check it out. And what you can do is just go down to the show notes of this episode and you can find my 5 favorite episodes of Opening Arguments. Start with Hillary Clinton's damn emails. It's the absolute best. And then, you'll see the rest of the other episodes that I absolutely love from Opening Arguments. But it's a fantastic show if you want a really hardcore assessment on the legal sphere of current events and everything that's going on, as well as deep dives into certain subjects that are particularly relevant. Opening Arguments is your show. And of course, once again, Andrew, thank you so much.
Oh, thank you so much. And thanks for the kind words. I love that you have top 5 favorite episodes. That's super cool. The Hillary Clinton episode is one of my favorites too. So,
I have a feeling like when the Mueller probe eventually is published, then those will be my favorite 10 episodes when you cover it. But until then, these will be the top 5.
Oh, thanks, Bryce.
Ms. Vito, please answer the question. Does the defense's case hold water?
No. Andrew is wrong.
Are you sure?
I'm positive.
Yes, even though we are not on Opening Arguments, Andrew was wrong on something. He said a couple of times in our conversation that Lilburn Boggs was a former ex-governor senator of Missouri. He was the former governor. He had never been a senator of Missouri. So that's a very small correction. I didn't catch it I think Andrew said it twice, and it just didn't occur to me that he had said it, or I didn't catch it at the time. Otherwise, I would have corrected it at the time, but I don't think if I would have issued that correction at the time that it would have substantively changed the conversation. But it was just worth a really quick Andrew was wrong segment. And of course, once again, I want to thank Andrew for coming on and helping us navigate through all of that. So with everything that Andrew and I discussed in mind, Joseph's legal troubles were far from over at this point. Now, he stepped into a clearing, but he was nowhere near out of the woods. His friends and enemies were well aware that he had prevailed on this one habeas corpus hearing, but that Missouri only had to get better documentation and he'd be quickly whisked back into court to be extradited to Missouri. Upon Joe's return to Nauvoo from Springfield, he was handed a letter from Orson Pratt, who Joe had suspected for a long time was in league with John C. Racket Bennett and Hinchpin Sidney Rigdon in trying to bring him down. Orson Pratt had been disciplined for his suspected actions and removed from his position as a member of the Quorum of 12 Apostles, but giving Joe this letter proved to Joe, to a certain extent anyway, that Pratt had his best interests in mind. So Joe immediately wrote to his legal counsel, Josiah Butterfield, copying this letter from John C. Bennett to Hinchpin Sidney Rigdon and Orson Pratt in its entirety, and sent that to Josiah Butterfield to make him aware of the coming storm that Joseph was facing. So this is printed in the Vogel History of the Church, Volume 5, page 238, and it's dated Nauvoo, January 16th, 1843. Quote, Josiah Butterfield, Esquire, Dear Sir, I now sit down to inform you of our safe arrival home on Tuesday last after a cold and troublesome journey of 4 days. We found our families well and cheerful. The news of our arrival was soon generally known, and when it was understood that justice had once more triumphed over oppression and the innocent been rescued from the power of mobocracy, gladness filled the hearts of the citizens of Nauvoo, and gratitude to those who had so nobly and manfully defended the cause of justice and innocence was universally manifest, and of course I rejoiced with them and felt like a free man at home. Yesterday, a letter was received by Sidney Rigdon, Esquire, from John C. Bennett, which was handed to me this morning. From that letter, it appears that Bennett was at Springfield a few days after we left there, and he is determined, if possible, to keep up the persecution against me. I herewith transmit a copy of this letter, and shall rely upon your counsel in the event of any further attempt to oppress me and deprive me of my liberty. But I am in hopes that Governor Ford will not gratify the spirit of oppression and mobocracy so glaringly manifest by the conduct of John C. Bennett. The following is a copy of his letter. And now this is the letter, which must have made Joe sweat bullets when it was handed to him by Orson Brain-Powered Pratt. Quote, Dear friends, it is a long time since I have written to you, and I should now much desire to see you, but I leave tonight for Missouri to meet the messenger charged with the arrest of Joseph Smith, Hiram Smith, Lyman White, and others for murder, burglary, treason, etc., etc., who will be demanded in a few days on new indictments, found by the grand jury of a called court on the original evidence and in relation to which a nolle prosequi was entered by the district attorney. New proceedings have been gotten up on the old charges, and no habeas corpus can save them. We shall try Smith on the Boggs case when we get him into Missouri. The war goes bravely on, and although Smith thinks he is now safe, the enemy is near, even at the door. He has awoke the wrong passenger. The governor will relinquish Joe up at once on the new requisition. There is but one opinion on the case, and that is, nothing can save Joe on a new requisition and demand predicated on the old charges of the institution of new writs. He must go to Missouri, but he shall not be harmed if he is not guilty. But he is a murderer, and must suffer the penalty of the law. Enough on this subject. I hope that both of you are kind and amiable families as well, and you will please give them all my best respects. I hope to see you all soon. When the officer arrives, I shall be near at hand. I shall see you all again. Please write to me at Independence immediately. Yours respectfully, signed, John C. Bennett. P.S. Will Mr. Rigdon please hand this letter to Mr. Pratt after reading? End quote. And now comes Joe's analysis of this letter in copying it word for word and then sending it to his legal counsel, Josiah Butterfield. Quote, In the foregoing, the designs of Bennett are very plainly manifest, and to see his rascality, you have only to read some articles from his pen published in the Times and Seasons about 2 years ago on the subject of the Missouri affair. I shall be happy to hear from you on this subject as soon as convenient, also if you received any communication from Washington. Yours very respectfully, signed Joseph Smith by William Clayton, agent. P.S. I would just remark that I am not at all indebted to Sidney Rigdon for this letter, but to Orson Pratt, who, after he had read it, immediately brought it to me. End quote. So that little postscript really exhibits how petty Joe could be, but the larger point remains that Missouri was back to devising how to get Joe within the confines of state custody. Bennett was working closely with Governor Reynolds to lay out their strategy to try Joe on, quote, new proceedings that have been gotten up on the old charges. And the emphasis in that letter, that's Bennett's emphasis. He was confident that, quote, no habeas corpus can then save Joseph Smith, end quote. Even if Joe wasn't guilty to accessory before the fact of the Boggs assassination attempt, he was still guilty of all those old charges, and Missouri wouldn't rest until they could finally try him in a proper jury trial and get the conviction they sought. This legal fight was far from over. However, this show of fealty by Orson Pratt was noticed by Joe, giving him the letter when Sidney Rigdon was trying to suppress that letter. Joe noticed it and baptized Orson Pratt and his wife in the Mississippi River for repentance, and then reinstated Orson Pratt back into his position in the Quorum of the 12 Apostles. Pratt must have been elated to be elevated back to his former glory at this time. He had repented. The same day, which is quite interesting as well, this is just a small aside, Joe gave a failed prophecy, and this was stricken from the original history of the church. However, because I'm reading the Dan Vogel Source and Text Critical Edition of the church, we get to read the failed prophecy, and this is from page 242 of Volume 5. Quote, Elder Hyde, now this is Orson Lahidem, as we called him, Orson Hyde. He is the missionary who went and dedicated the land of Jerusalem, Palestine. Now this is the prophecy. Elder Hyde told of the excellent white wine he drank in the east, inserted Palestine. Joseph prophesied in the name of the Lord that he would drink wine with him in that country, end quote. That's a Joseph Smith prophecy you don't really hear much about, is it? But there it is. It's recorded in Book D1, page 1457, with the editorial note, reconsider, next to it, and then it was removed from the history of the church, and thus removed from history in general. Joseph Smith prophesied that he would drink Palestinian wine with Orson Hyde in 1843, but he died a year and a half later. What is a prophet who makes false prophecies? A liar. Just a dude talking with thousands of people fawning over his every word. So the last point that I want to discuss today, and this does wrap into the larger discussion, and it's not really an aside like failed prophecies like that. Let me preface this the point that I'm about to make here. Dream divination is absolutely worthless, unless the dream that we're discussing is believed in by the person reporting it to have been prophetic or divinatory in some way. When somebody has a dream, trying to ascribe specific meaning to it is absolutely pointless. However, when Joe had his dreams recorded, it needs to be understood that he regarded them as prophetic because he regarded every one of his actions to be prophetic. Joseph Smith lived in a world moved and shaped by the will of Elohim. Random coincidences to Joseph Smith were the will of God, showering blessings upon his chosen servant. Joe standing trial for his illegal actions wasn't the will of proper law being carried out. It was the will of the adversary trying to destroy the mission and work of God on earth. Joe didn't operate in a naturalistic world. So when he had his dreams recorded, we can be assured that he took great significance from them. Even if this overactive sleep state simply is what happens when somebody is under as much stress as Joe was at this time. So here's his dream from the history of the church. Quote, I related my dream. I dreamed this morning that I was in the lobby of the Representatives Hall at Springfield when some of the members who did not like my being there began to mar and cut and pound my shins with pieces of iron. I bore it as long as I could, then jumped over the rail into the hall, caught a rod of iron and went at them, cursing and swearing at them in the most awful manner, and drove them all out of the house. I went to the door and told them to send me a clerk, and I would make some laws that would do good. There was quite a collection around the state house trying to raise an army to take me, and there were many horses tied around the square. I thought they would not have the privilege of getting me, so I took a rod of iron and mowed my way through their ranks, looking after the best racehorse, thinking they might catch me where they could find me when I awoke. End quote. Now, Whether or not that's what Joe actually dreamt, that doesn't matter. The way he reported his dream reveals deeper desires and intentions that must not be ignored. What do I mean by that? Well, by January of 1843, Joe had spent a lot of time fraternizing with very powerful people. I would argue that his association with governors and senators, military leaders, and many other high-ranking politicians and military officials and whatnot, that had a humanizing effect on those people in Joseph Smith's mind. So let me qualify that further. Let's face it, the barrier for entry into most government positions is simply likability, especially in the 19th century. Joe had proven through his 13-year ministry that he was very likable. How hard could it be to become a politician? Besides, Joe operated by the gift and power of God. Every action he took was via direction from his conception of God. Everything which happened to him was by the power of God. And if God wanted him to rule the government, God would put him in that position. See, Joe had incredible aspirations ahead of him. There can be no doubt that he was contemplating being president of the United States at this time. His dream, his reported dream here, it reads like the fever dream state of a revolutionary. He was in the representative hall of the state of Illinois when he was attacked by a bunch of legislators, and then he picks up a weapon and drives them all away single-handedly. Then he dreams of sending for a clerk so that he can make his own laws that, quote, would do good, end quote. Good for what? Good for whom? Then they raise an entire army against Joseph Smith, and he single-handedly battles them all and then steals their best racehorse and makes his escape. Honestly, this is just a dream, but what better analogy for Joseph Smith at this time in Nauvoo history? It couldn't possibly be more apt. He was the kingpin of a criminal empire who ravenously sought increasing power and would stop at nothing to become king of the world. This wasn't just a dream. This was Joe's prophecies. This was Joe's most deep-seated desires playing themselves out in his mind. Less than a year after this time, he forms his Council of 50, established for the sole purpose of being the governing body of America once the secular government collapsed. And what I find most fascinating about Joseph Smith's entire legal sphere at this time is that he was clearly testing the system, right? He was a kind of demagogue who would push everything to the point just before it broke. He ducked and dodged every legal proceeding brought against him, many of which were efforts to curtail his power or make him responsible for his illegal actions, but none of them prevailed. Joe triumphed over them all, and when he didn't triumph, he simply ran away from his problems on the best racehorse. Joe was testing the boundaries that Americans in the 1840s would deal with before the legal process would completely break down and vigilante justice became the only seemingly reasonable answer. With that said, when Joe was assassinated in Carthage a mere 17 months from where our timeline currently rests, the religious aspect, the religious persecution as it was claimed, was such a small piece to that puzzle. And sure, I mean, it played a part, but the point is, Joe confounded his enemies because the average American and the American government isn't equipped to deal with people like a Joseph Smith. He constructed a fraudulent empire built on loans that he was constantly defaulting on. He waged war and established himself as a military leader in Missouri, but then cried foul when other military leaders attempted to try him in a court-martial. He was a libertine under the sanctimonious garb of religious ritualism, and when challenged about his libertine nature, he just said that it was all the will and power of God. He knows because he speaks for God. Not only that, he was the one true prophet. He was also the one primary government authority in Nauvoo. He and his best buddies ran the town however they saw fit. The incredibly broad powers granted by the Nauvoo Charter and the overreach granted to the municipal court of Nauvoo made it possible for the city to harbor fugitives, murderers, and horse thieves, and when those persons' arrest was called for, the Nauvoo court would just issue a writ of habeas corpus and those people would walk. Nauvoo was a criminal empire, and it was run by Missouri's public enemy number one after his failed military campaign and his escape from state custody in Missouri. Sure, Joe was assassinated in 1844, but I would be willing to bet that when that happened, there were probably a lot more people in America who thought it was justified and a long time coming than who thought that he was taken from the earth before he fulfilled his mission. All right, that is going to do it for today. Just a quick reminder, we are still trying to raise money for Brother Jake. This is for the Frost family. Now, if you haven't heard, or if this is, this is your first episode that you're listening to, or in a long time, or whatever the case may be, friend of the show, Brother Jake, who is a fellow ex-Mormon content creator, suffered a major cardiac event, and there is currently a GoFundMe up to help the family get back up on their feet and to help him with the incoming medical costs that will, probably be hanging over the Frost family for quite some time. So it is GoFundMe.com/GoJakeGo. Now, in order to incentivize you, if you donate any amount to it and you forward your donation receipt to nakedmormonism@gmail.com, you're going to get a shout out on the show. Just give you, thanks for donating. The safety net of ex-Mormons, once, we leave the church, we don't have the church's safety net anymore. So the safety net of ex-Mormons in this awesome community thanks you for your donation. However, if you donate $50 or more, you're going to get written into a treasure dig. Now, if you want to hear what that's like, go back to episode 136, and you can hear the treasure dig in the last half of that episode. Now, we've had one more entry of this, so we're going to wait to do another treasure dig for a couple of weeks. We're going to wait until the fundraiser comes out, and hopefully there will be more entries. We're running this for another 2 weeks. The 31st, January 31st is going to be the last day that we are running this, and then we will do our treasure dig probably that week or the week following that. And that's going to be the next time that you have a chance to get written into the treasure dig. But that's only if you donate $50 or more to Jake's GoFundMe. That's GoFundMe.com/GoJakeGo. But there's even more incentive. If you donate $100 or more, then you get drawn into the treasure dig by the amazing artistic talent of Mark Elwood of theglasslooker.com. Mark Elwood is currently putting together a graphic novel of Joseph Smith's treasure digs, and his art style is really awesome. So go check that out, and if you donate $100 or more, Mark is going to draw you into the treasure dig. So, like I said, we have one of these entries banked. We're going to be doing the treasure dig here in a couple of weeks, and with all of that said, of course, thank you to those of you who do support Jake right now on GoFundMe.com/GoJakeGo. I'm sure the Frost family really, really, truly appreciates it. Of course, with that said, we do have one new patron to thank at patreon.com/nakedmormonism. That is Beth M. Beth, thank you so much for pledging to support this show and keep the lights going here at Ground Gnome Studios. Well, I mean, come on. We run off of hydroelectric power here in Seattle. It's a pretty reliable source of electricity, but, you make sure, you ensure that it stays on. So to all of our patrons and the new patron, thank you so much, and I hope you enjoy the extra content that you get on the Patreon feed of this show. And, of course, another quick final announcement. Friend of the show, Uncle Mark from the How to Heretic podcast is going to be on Truth Wanted. Now, Truth Wanted is a live call-in street epistemology YouTube channel that airs every Friday night at 7 p.m. Central Time. So you can check the show notes of this show, or you can go to YouTube and type in Truth Wanted, and you can find their channel, subscribe to him. Friend of the show, Dan, runs that channel, and Uncle Mark is going to be guest hosting with the Street Epistemology, and they're hoping to get some calls. So if you listen to this before next Friday night, that's going to be Friday the 18th of January, 2019. If you're listening to this in the backlog, I'm sorry. But if you're listening to it before then, it'd be really cool to tune in. I'm sure going to be watching. I'm going to be hanging out in the YouTube comments section and of course, jabbing at Mark whenever he says something that I don't agree with, whatever the case may be. No, we have fun. We do. And, of course, with all of that said, I think we are all done for tonight. Of course, I want to thank all of you for hitting that download button, for listening every week. And then, of course, one more announcement to bother all of you with. This week's episode, of Glassbox Podcast, I think I told you last week that we were going to be covering the temple changes. Something came up. We are actually going to wait on that. Instead, what we covered were changes of a different nature. I invited friend of the show, Joseph Geisner, on to talk about changes that have been made in public addresses of General Conference by the Church and disunity that happens within the Quorum of Apostles. And he walked us through more than 100 years of the history of censoring General Conference addresses. It was a really fascinating conversation, and as is the case when you talk to historians, we ended up talking for like 5.5 hours. So you get 3 parts over there on the Glassbox podcast for this week. If it's something that might interest you, go check it out. If not, then that's cool. Stick around here, and then we'll talk to you next week. You guys are all awesome. I say you guys colloquially. Y'all are awesome. So thank you so much, and I'll talk to you next time here on the Naked Mormonism Podcast. This podcast is produced with the help of Julie Briscoe as social media manager, Brian Ziegenhagen as audio engineer, and Andrew Torrez of the law offices of P. Andrew Torrez in the Opening Arguments podcast as legal counsel. Music is written and performed by Jason Camo of aloststateofmind.com and used with permission. Naked Mormonism is a production of Ground Gnomes LLC, copyright 2019, all rights reserved.